All right, good afternoon, ladies and gentlemen. We now have a quorum, and we have several bills on the calendar, I think about 10 altogether. I'm going to start out with the quicker moving bills, and then as we get down toward the end, some of these bills may require a little testimony, so I'm not sure how long that'll go. We do have a limit as to the time we have today, so I may, if we get into a long discussion on some of these bills, I may be limiting the amount of discussion that we have. We have several, I'll call them judicial celebrities in the room. We have Judges Joe Booth and Curry Mingledorf. Thank you for being here. Al Wong also, thank you. And we have District Attorney Brad Smith, I think is behind the pole here. So did I miss anybody? We have a sheriff back there, I know. Introduce yourself, sir.
Sheriff Carl Steve, Banks County.
Yes, sir. Thank you for being here also. All right. With that, I want to call up House Bill 404. We've had discussion on this already. This will be for consideration by the committee. Is there any questions for the author of the bill? What's the pleasure of the committee?
Hey, okay.
Go ahead.
You know, I was just gonna I know we got a busy day. We're working off of LC 5005449S. I just wanted to highlight just a couple of changes real quick, and then obviously let the will of the committee go. But we did lower the cap on the rent on the deposits from 3 months to 2 months. We extended the right to cure to 3 business days, which I think is important if it happens on a Friday. That way, you're not saying on Monday you have to leave. And then we also eliminated the criminal tenant piece. It was too complicated with the short time that we have. Obviously, something that we want to address, but we just couldn't come with a clear answer on it. So, without that, Chairman, thank you for having me.
All right. Any questions by the committee? Do I hear a motion? I hear a motion and a second. All those in favor say aye. Aye. Any opposed?
Thank you, Chairman.
Bill passes.
You guys. I've never been so pleasured to leave such a fine place.
You don't have to leave.
Burning elsewhere. God bless, guys.
Let's see, has Representative Cooper made it here yet? I don't see her. All right, let me jump over then. Representative Ridley? Is he in there? Let's grab him. This will be House Bill 248.
Good morning, good afternoon.
Yes, sir.
Well, I made it 7 years here without having to be in here the first time. I got House Bill 248 LC 393831S. And all this bill does is adds extra courts that the Sheriff's Department's already having, all our sheriffs are already having to be at. And I think it increases the pay part of it. No, it keeps the pay same. So they're already getting paid for some of the courses. It's going to add 3 additional ones that they already have to be at, $385.90 a month. As you all know, as we all know, our sheriffs are always there having to be at the courts. And so this is just ones that they have not been getting paid for. So all we're doing is saying that they will.
So this will be $385.90 for each court up to 3.
Yes, sir.
Okay. All right. Any questions by the committee? Is there anybody to speak on the bill?
If necessary, Mr. Chairman, Terry Norris of the Sheriff's Association.
I'll leave it up to you if you feel like you want to testify.
This is an important bill for the sheriffs. Thank you for this consideration.
Thank you, sir. All right. What's the will of the committee? Got a motion? Do I hear a second? Got a motion and a second. All those in favor say aye. Aye. Any opposed? Bill passes.
Thank y'all.
All right. I still don't see Sharon Cooper. members?
Ready.
Okay, I've got each of those microphones on for y'all, so. All right, go ahead.
Chairman Gunter and members of the committee, I am here today to present to you House Bill 543. To my left is Judge Al Wong, the legendary Judge Al Wong of the State Court of DeKalb County, and I know we have some legendary DeKalb County lawyers in here as well. So Judge Wong, in addition to running a great courtroom in DeKalb State Court, has spent time with the Judicial Council of Georgia, and that is where the idea for this bill comes. This is a state court bill that would allow 6-person juries to occur in state courts for matters $100,000 and below. Currently, the law allows 6-person juries in state court for $25,000 and below. And as somebody who's tried some 2 or 3 day civil cases, trying a jury trial over $25,000 just is never going to happen. I wonder how many of y'all know of one that's happened, but a $100,000 6-person jury will happen a lot more than a $25,000 case. The public policy behind this is better use of limited resources, of having jurors brought in. You have half as many jury strikes and jurors who are needed. You're going to save financial resources, taxpayer money. You're going to have faster resolution and dispositions. You're going to able to go through more civil cases and go through your docket. That is going to let people have their day in court who want to do it, but it's also going to prompt settlement by having people facing a jury more often. It'll reduce the civil case backlog. This has been well vetted by plaintiffs' lawyers, defense lawyers, insurance companies, judges, court personnel, the Judicial Council of Georgia, the State Bar of Georgia Advisory Committee on Legislation. And I think at this point, other than to say this is something that will promote judicial economy and promote the right to trial by jury, I think I'm going to turn it over to Judge Wong at this time, and he and I will be glad to answer questions. Judge Wong, thank you for coming to the House Judiciary Committee.
Thank you, Mr. Chairman, members of the committee. I'm happy to answer any questions. I can't say it any better than he did.
Okay.
And I'm not legendary, by the way.
I don't know about that.
You are to me. You are to me and to many people in this committee.
All right.
The only point I want to make, too, is that this has been well vetted for past 2 years with the defense bar, the plaintiff's bar, the carrier, the corporate representative of the carrier, and the number that we came up with was also via survey and very data-driven. The last time, the $25,000 limit had been in existence for 22 years. So it was, before that it was 10,000, before that it was 5,000 in the mid-70s. And in 2002, you remember our old friend J. Max Davis, he's the one who got the bill passed to increase it to 25, and it's been at that number since. So for no other reason, given inflation and so on, I think this is a really good court management move, so we appreciate your consideration.
Thank you, Judge. Representative Oliver?
Thank you for being here. Thank you for all your leadership in DeKalb.
Thank you.
You answered the question was on my mind, how long had it been? And I wasn't here in 2002, so I didn't remember that year. But thank you. This is a good efficiency model, and there's been no complaints and a lot of happiness over the prior opportunity to go to a 6-person jury. Thank you.
Thank you.
I see no other questions, so if that's it, thank you, gentlemen. Thank you. What's the will of the committee? Got a motion and a second. All those in favor say aye. Aye. Any opposed? All right, bill passes.
Thank you.
Thank you very much.
5:30? Either way, whatever you feel like doing. What's your number?
13.
All right.
Thank you, Mr. Chairman. I bring before the committee House Bill 530, and this is a piece of legislation that we've been working with interested parties on for several weeks now, and we've got to a place where we have at least a bill. I won't say that every party is satisfied, but I will say that the parties have been working to get to this point. Essentially, what the bill does is it is what's referred to as the apex doctrine, and I'm going to put this in just plain language, and this is how it works. So the issue that was brought to us is whether or not it is reasonable to bring in a high-ranking officer to do a deposition when they do not have unique knowledge of whatever it is the information being sought. And there's a court case that sort of articulates the issue here, and it's General Motors v. Buchanan. And essentially what the court came to in the current state of the law in Georgia is that the discovery statute is broader in Georgia than that of its counterpart at the federal level. Particularly when a party that is opposing a deposition is wanting a protective order. The court in this case struck down the request for or did not grant the protective order to GM because though GM was arguing that the president of GM was, or the CEO of GM had unique scheduling constraints. They only argued that only argued the federal statute and saying that we shouldn't have to be deposed because of this federal statute. And the court said that Georgia has a broader discovery statute, and I want to make sure I use the correct terminology here. And unless there is evidence that the proponent of the deposition is seeking in bad faith or harassment, is motivated by bad faith or harassment, then as long as it meets the standard of Georgia, it doesn't have to meet the more constrained federal standard. And so what we've done here is essentially call out the pertinent elements of the Buchanan case so as to lay out the opportunity for the court to look at the elements and determine whether or not a deposition it should be sought for a high-ranking officer. And we also extended this officer, and I can run through the bill line by line if you like. And but let's start right here at 42, if you will. We defined officer as a former or current high-ranking officer of an organization, but also extended this to the organization being a large and complex entity, whether public or private. So this would extend to your CEO of a private GM, or it would also extend to your department head of, say, Department of Revenue for the state of Georgia. And then we lay out the provisions for when you can seek a protective order, and we spelled out the provisions in lines 46 through 60 for good cause. And some of the proponents and opponents in here I think we're down to arguing about one or two words, which is, I think, it's a good spot because everybody's unhappy, and that's what I've been told is if everybody's unhappy, we may be in a good spot. So we're arguing about literally one or two words, and I'll let those folks make their case for or against. But I think this is a step in the right direction where someone cannot get the deposition just for purely harassment purposes, and it's a reasonable standard to offer a protective order when there is someone an officer that is high ranking and someone else has the knowledge. It's not unique to CEO or the department head. That's essentially what the bill is and what it does. And I'd love to stand for questions because I think I've rambled on here.
Any questions from the committee for the author? All right, hearing none. At this time, I'll call, no, we're on 5:30. Oh, he's, okay. Dan Snipes. Sorry, I saw you on 470. I didn't see it on 5:30.
No problem, Mr. Chairman. Mr. Chairman, members of the committee, I'm Dan Snipes. I'm a past president of the Georgia Trial Lawyers Association and Practice Law in Statesboro. As Whip Burchett said, this is a matter that we've been working on with other interested parties now for about a month. The genesis of this legislation is that the Georgia Supreme Court issued a decision, Buchanan versus General Motors, that dealt with when it was appropriate for an attorney to take the deposition of the CEO of General Motors. And what the Georgia Supreme Court there struck a balancing test. And essentially what it looked at was that Georgia has a right to full and complete discovery under 9/11/26, but that right has to be weighed against whether or not the discovery sought is oppressive or burdensome or just unduly expensive. And what we try to do with this is try to take a 19-page Supreme Court decision and put it into the code so a Superior Court or State Court judge can go to a statute and look at the factors that are discussed in Buchanan and try to make it so it's a two-paragraph answer rather than a 19-page opinion. The gist of it is, and GTLA's position is, that the deposition of such an apex person should be rare and very limited when it occurs, but there are circumstances where that person, because of prior positions within the organization or because of their position now, may have very unique, relevant information to the subject matter of the case, and that deposition shouldn't be precluded just because that person is a high-ranking official. That's one of the things our system of justice is founded on. Regardless of your title or your status in life, you're still subject to both the civil and criminal systems. So what we're trying to do is take the Buchanan decision and take that balance and place it into the code.
Okay. All right. Any questions? Seeing none, thank you.
And I guess I would add, though, this is still something as of yesterday and today, we're still having some back and forth, like Whip Burchett said, about certain provisions in the statute. In order to keep the momentum going, though, we need to move this bill forward, so we've got a vehicle to continue to work on. But we've made a lot of progress, and I think we've got a framework which forms the basis for going forward.
All right. Thank you, sir.
Thank you.
All right. Joshua Wright and Megan Hanson. Y'all here? All right. Introduce yourself, please.
Sure. Mr. Chairman, I'm Megan Hanson. I'm with Georgians for Lawsuit Reform. So mark this down. This may be one of the few times that Georgians for Lawsuit Reform and GTLA are on the same page. I agree with what Mr. Snipes said as far as what we're trying to do with this bill. I think that we have made really great progress in moving forward. As what Burchett said, there are two words that we would like to see struck. And really, it's just because we think that less ambiguity in a law is always a better thing. The two words, I'm trying to do this from memory, I want to say line 41, unique, as it relates to scheduling. And then line 43 was complex, as it relates to large. Happy to go into why we think those need to be struck, but really it's just less litigation is always better, less to fight about, and also less interpretation or different interpretations. We would just like to see a streamlined statute.
All right. Any questions?
I'm just going to
Representative
help Ms. Hanson out because she did do that well from memory, but it's line 43 unique and line 45 complex is what she's talking about. Thank you, Mr. Chairman.
Yeah, she probably saw an older version, so. All right. Okay, thank you.
Thank you so much.
Next. Will Barnett.
Afternoon. Will Barnett. I'm Associate General Counsel with the Home Depot. Been with the Home Depot for 19 years almost, and I'm responsible for managing our commercial litigation team. My team defends lawsuits across the country in state and federal courts, including here in Georgia. I really appreciate the opportunity to talk to the committee today about the Apex Doctrine. This is a very important priority for the company. We think it's very important that Georgia law recognize the Apex Doctrine. You know, preparing for an ordinary deposition can be an expensive and time-consuming matter. Discovery costs really drive the expense of litigation, as I'm sure you're all aware. Those costs are really ratcheted up when it's an executive who's being deposed. Given the time and travel demands placed on executives, just scheduling could be a real issue. And obviously an executive deposition is a much more higher profile event for a corporate defendant. Given all these constraints on the executive's time and the disruption to the business that can be caused by trying to schedule these type of depositions, what I've seen is these types of depositions can be really used as a cudgel by plaintiffs to try to drive a settlement, whatever the merits of a particular case. That's been my experience at Home Depot. We often see depositions sought by plaintiffs with key senior executives, and in my view, this is done to drive up the cost and burden of litigation. Again, my experience has been these executives almost always have nothing to do with the case, don't have any personal knowledge about the case. And in those rare instances where it is a key executive who's involved in the case, there is always a lower level and more knowledgeable employee that the information could be sought from by either a personal knowledge deposition of that employee or a corporate representative deposition. So Home Depot is fully supportive of Apex Doctrine protection. Really think it's an important matter. I'm glad the committee is taking up. I would second Ms. Hanson's comments that unique, and I'm sorry what the revised language is, but unique scheduling demands as part of a certification by an executive not to give a deposition. We would just say that at a Fortune 500 company like the Home Depot, and there are a number of other similar companies in Georgia, by definition, those executives have enormous demands on their time and responsibilities. There shouldn't be satellite litigation about whether they have unique and exclusive, or whatever the terminology was, demands on their schedule. We think really the focus should be on just lack of personal knowledge and other witnesses more suited to give the testimony. I really appreciate the opportunity to address you today. Happy to answer any questions.
All right. Representative Smith, or Chairman Smith, excuse me.
Mr. Chairman. Question real quick. Y'all want to change these words out. What's the definition of unique, and what would be the definition of complex here in particular?
Is that to me?
Yes, sir.
Again, I would strike that language.
Yes, sir.
I think an executive at a company like the Home Depot should not have to show that they have unique demands on their time.
Whip
Thank
Burnett.
you. Give me your name one more time.
Will Barnett.
Thank you, Mr. Barnett. I appreciate it. What's the definition of extensive?
Again, I think that would just lead to litigation. I think the certification should be, I'm an officer at the Home Depot or a similarly situated company. I lack personal knowledge about this event.
How do we constrain those parameters without defining what those parameters are?
Well, an officer at our company is objectively defined. There's a couple hundred people that qualify.
So let's say the officer of a a restaurant chain, is that what you think they should avail themselves of this protection?
Again, I would need to look at how you've defined large corporation, I think is the terminology.
So you see the problem we have? We want to constrain this to who we want to protect, but we don't want to too broadly define it so that every company. I mean, I have a couple companies. It's just me and my wife. I'm the CEO. Should I be protected?
I think if you're talking about large corporations, we would say no. I guess just to say, Home Depot has over 400,000 employees. We're talking about a couple hundred people objectively that would qualify as an officer of the company.
So you just want Fortune 500 companies?
Well, I think the bill talks about large corporations. So you could define that objectively. I mean, that's the legislature's role.
Mm-hmm.
But also, to your point, respectfully, unique is a subjective term. That's not any kind of objective standard. And I think it would just lead to satellite litigation about who qualifies.
Neither is extensive, but you're not opposing that.
Oh, I'm sorry, I am. I was not aware of the revised
Okay.
language. Again, the company's view is this should just be people who are officers and lack the personal knowledge.
I certainly respect the gentleman's opinion. I appreciate it, though. Thank you.
Thank you.
Chairman Smith? Hang on, sir.
Sorry, we should have said something a little while ago. Would you agree that complicated is a cousin of the word complex?
I'm sorry.
Complex and complicated, they're both cousins in the English vernacular, no matter how I pronounce either one of them, wouldn't you say?
Certainly.
So, as far, and I'm hung up on this complex and unique thing, and so I've been over here in a good old Black's Law Dictionary that's probably as old as Rusty Sewell when he was in law school. But if you're interested in this, the word complicated here in this version, it says consisting of many parts or particulars not easily severable in thought, hard to understand or explain, involved, intricate, confused. Now that's a court case up in Ohio, so I don't know how much we really care about it down here, but consisting of many parts. That's the part of that definition that I'm looking at, and so you go into complex, I mean, dadgum, complex is going to be just about any organization. I mean, you got a farm out there that's got trucks that hauls the manure out, and then one truck that hauls fencing supplies in or whatever it may be. I mean, you get complex real quick, and I mean, you basically, and Mr. Whip's example that he gave you, you're basically keeping just about every business owner, CEO, from ever being involved in a deposition, unless some extraordinary case is made to have them testify in a deposition. Would that not be true?
I don't believe that's the text of the current legislation. I think it talks about large companies. I mean, correct me if I'm wrong.
Right.
But I'm sorry.
But moving to complex, and you know, we all know that judges read definitions and such when they're interpreting statutes. Complex could start covering a whole lot more than just Home Depot CEO, if we were to go to that word, correct?
Just to be clear, I'm not asking for just Home Depot CEO.
Right.
I think
Just
that
for example. Just for example there.
Well, Apex doctrine traditionally, and it's applied throughout the country, so it's not, we're not asking for anything out of the ordinary here. What we're asking for are officers at large companies, corporations who lack personal knowledge about a case to have to give testimony. And again, my personal experience has been this is used basically to try to force settlements, drive up costs, harass corporate defendants. That's why it's needed. I'm not saying if you form an individual LLC or something that would apply. I don't think that's in the draft legislation, as I understand it.
Thank you.
All right, I see no other questions. Thank you, sir.
Thank you.
Emily Johnson?
Good afternoon. My name is Emily Johnson. I am the Senior Vice President and Deputy General Counsel of United Parcel Service, or UPS, headquartered in Georgia. And I am here to offer testimony on behalf of UPS in support of the bill that involves the Apex Doctrine. So as I mentioned, UPS is headquartered in Georgia. Our CEO and our 8 most senior officers and executives on our executive leadership team are also based here in Georgia, as are a multitude of other officers and executives based at our corporate headquarters. And we believe, like the gentleman from Home Depot suggested, that legislation is needed to be adopted in order to apply consistent standards that judges can apply when litigants seek to depose or conduct discovery involving executives and officers in Georgia. And there are 2 reasons for this. One is the potential for abusive discovery, and the second is the potential for an undue burden and distraction on executives that have comparatively little knowledge of relevant facts. So the importance of a deterrent to abusive discovery is based on the fact that a lack of consistent framework for judges to apply today creates a perverse incentive in 2 respects. One is forum shopping in Georgia state courts, and the other is seeking depositions of corporate executives not for the purpose of seeking relevant information for the actual lawsuit, but for other purposes, as previously has been mentioned, like pressuring companies to settle cases to avoid getting bogged down in deposition preparation and testimony, taking executives and officers away from their vital executive responsibilities. And then the second factor is why it's important to have a consistent framework for judges to apply is to avoid unwarranted distraction and burden on executives given their little to no personal knowledge of relevant information and the alternative means of getting discovery of relevant information. So as has been mentioned, deposition, preparation, and testimony takes hours of time. And if you multiply that by the number of lawsuits that can and are actually filed in the state of Georgia against a company, if executives and officers could be subjected to depositions without any legal constraints, like those afforded by the Apex Doctrine, then they would have insufficient time to run their companies. And they would have insufficient time to do things like managing risk and managing people and managing finances, liaising with the board of directors and shareholders and customers, and generating income for their stakeholders, all of their stakeholders. And these are just to name a few of the vital responsibilities that executives and officers have. So thanks for the opportunity to address the topic today and for your consideration, and I'll answer any questions you may have.
You're familiar with other statutes in other states that deal with this issue?
Yes.
Okay. Now, we've had it brought up that unique, extensive, and complex are words that shouldn't be in this bill. What do you say about that?
Well, I agree wholeheartedly. I am most familiar with the Florida statute, which, it's my understanding, don't contain those kinds of qualifiers. And I think the courts are able in Florida to consistently apply the standard in a meaningful way, in a practical way, without qualifiers like that are hard to define, as was previously discussed, and almost impossible, really, based on their subjectivity and vague meaning.
So how do they describe such an officer of the company that would be protected under an Apex Doctrine? How do they, if you take out unique and extensive, then it's just somebody with scheduling demands?
Well, I actually think the crux of the issue is the lack of personal knowledge. Officers and executives have knowledge about company policies and issues of public policy, but lawsuits center around actual facts, very specific facts, and normally in these situations, the officers and executives don't have knowledge of those specific facts, and that's really what drives this issue, I think, and it's not that difficult to demonstrate a lack of personal knowledge about a set of facts. And so I don't think you need these kinds of qualifiers for judges to be able to apply the standard.
So it's a practice issue in the court to be able to show that? Is that what you're saying?
Yes.
Okay. Any other questions by the committee? Burchett?
Thanks for coming and giving testimony. And remind me of the company?
UPS.
UPS. Is UPS a pretty large company?
Yes.
All right. Is the CEO pretty unique in their scheduling, extensive scheduling?
Our CEO has extensive scheduling demands. I don't know how unique it is.
Is it unique to UPS?
No.
It's not. Is it unique to a large company?
No.
It is extensive but not unique.
Yes.
Okay. Can you argue that it's unique?
It'd be very difficult to try to think of arguments in support of a word or a standard like unique.
Is my scheduling unique to yours?
I don't know.
You don't know. So my schedule is not unique to yours. As it is to yours, sorry.
I mean, everybody has a unique schedule. There may be some commonalities based on things like what your position is or what your organization is like.
Everybody has a unique schedule.
Yes.
So you could argue that my schedule's unique as it is to yours, or as to yours, excuse me.
Sure.
Thank you.
Any other questions? Thank you, ma'am.
Thank you.
That it? All right. Any discussion of the bill by the committee? Representative Kelly.
Move to pass.
Got a motion and a second. All those in favor say aye.
Aye.
Any opposed? Bill passes. All right, Chairman Cooper, if you want to come up. This will be House Bill 470.
Chairman Cooper's asked that I sit with her.
Please do.
So,
I tell you what, if y'all want to,
move this
that way you can share both mics.
Thank you, Mr. Chairman, and members of the committee for considering House Bill 470. I will tell you that it has taken me 27 years to get to this committee. And
Was that on purpose?
Yes, sir, it was. So I thank it very much that Mr. Snipes is with me. As we know, with hospitals and doctors, there are sometimes unintended consequences and accidents and things do happen. And a group of us had with lawyers and with the physicians and a small group of advocates on a different way of approaching how we resolve some of these smaller issues to bring closure to the patient and their families and to the physician or the hospital that's involved, and also as a way that it benefits and makes sure that they have good legal advice and representation. And with that, since I am not an attorney, Mr. Snipes said that he would walk you through the bill and ask any lawyer questions, answer them.
All right.
Thank you.
Go ahead.
And as Chairman Cooper mentioned, this is a discussion that I believe originally started in 2018. And when GTLA was approached by interested persons with our healthcare delivery providers, we have sat down and quite frankly, because Chairman Cooper has just worked with us continually, we've been drafting. So what you see HB 470 is a result of about 18 months, though, of pretty intense back and forth about creating a process by which if a healthcare provider feels like there's been a bad outcome, it gives them a chance to engage in an open and honest discussion, the candor process. And it's different than a mediation because rather than taking a one-day approach to trying to discuss a problem, it opens a window of a 60-day period of time by which there's an exchange of information. And the goal is that if there are bad outcomes that aren't the result of actionable negligence, then the family of someone who's been affected by that adverse outcome can understand what occurred without having to engage in discovery. Because a lot of times, unless you file a lawsuit, you can't compel documents to be produced. And then also, though, if there are circumstances where there was actionable negligence, it gives the parties a chance to resolve the matter without there being litigation. And there's a benefit to the medical providers in this bill in that if money's paid as a result of the candor process, it's not defined as a settlement of a medical malpractice action, and it's not subject to the federal reporting requirements. So it gives an incentive to the medical providers to sit down and have this open and honest conversation. And we've gone to great lengths also in Section 1 and 2 to try to make sure that while candor may be a process to know what you need to learn in the event you can't resolve the case, the candor communications are going to be confidential, and they're not going to be something that if you make an admission or you make a statement during the candor process that it can be used against you later. And those are the types of things, though, that over time has taken a lot of work. One of the things the medical community did that was a big concession on their part is that if a party's not represented during the 60-day candor discussion, the statute of limitations will be told for non-represented parties. So from our perspective, we didn't want persons to be engaging in a process and not realizing the clock was running while they were engaged in the process. So the big picture is Section 1 and 2 sets out the definitions and it sets out the process in order to try to incentivize all interested parties to try to reach resolutions that may not be able to be reached without there being litigation otherwise. And then the last section of the bill tries to recognize the fact that for all parties who are in litigation now, because just about all medical records now are kept in electronic format, and most of the times when parties request records, they want them in electronic format, and because those documents can be converted electronically and transferred electronically, we're still charging per page copying cost for all medical records. And if the Section 3 doesn't change what would be the per page for actual physical copies, but it changes to flat fees what would be the cost associated with electronic medical record transfer or PDF versions of medical records.
Okay.
So that's where we are.
This really wasn't my area of practice, so help me out here. There's no conflict with HIPAA at all?
Well, so HIPAA is something if the patient or if the patient's family, a representative can sign the releases to get access to the.
So they still got to deal with it.
You still have to do. So there
Okay.
still has to be medical authorizations and medical releases signed, but the parties that would have to be the real parties in interest in any civil litigation have the ability to execute the necessary medical authorization and HIPAA releases.
Okay, all right. Any questions by the committee? Okay, not sure who hit it first. Representative Silcox.
Thank you, Mr. Chairman. I just want to thank Chairman Cooper for bringing this bill. I know there are a lot of times in medical situations where there are a lot of emotions involved, and people may be explosive and angry and not understand what has happened when there's actually no negligence. It was just something that happened in the medical procedure. So I think this is a great opportunity to work out something without involving the cost, and particularly the reporting requirements, as you mentioned, Mr. Snipes. I think this is really a great step in the right direction. So I appreciate it.
And if I can say something, what they're finding is that we're having a lot of physician burnout. And one of them is having something like this that's unresolved hanging over their head. The other thing is that when patients can talk about it and we can identify where something's gone wrong, then it leads to that being corrected to keep it from happening again. And they're finding this ability to be honest and to talk about it does decrease the number of accidents and repeat situations that are a danger to patients.
All right, Representative Reed.
Mr. Chairman, a quick question for each of the sponsors. Mr. Snipes, do you believe the Cantor proceeding could lead to compensation on smaller claims that our current system may not provide for in practicality?
Certainly, because it provides an opportunity to have that discussion. Now, the way this is set up, the medical provider is the one who initiates the discussion, but I certainly think right now that for cases that don't involve catastrophic injury, because of the expert requirements, because of the causation experts you have to have, this type of litigation is just quite frankly very expensive. And this should open the door for more people to be able to learn, what was the cause of what was a negative outcome.
And Chairwoman Cooper, one thing I was very persuaded by that you told me about was the fact that we were buying into a successful model from other states. Can you tell us about some of the success stories of some of the states who were ahead of Georgia on this?
Well, we have Colorado passed it with no dissenting votes from either party. The same happened in Iowa. In Utah, there was one dissenting vote when it went through the first level, but then in the end, I think that it was unanimous on both sides. So which is really great to have both parties working together. But in one of the states, it's been in effect for about a year and a half. And, I would say if you've had 100 situations where standard was used, like maybe 3 or 4 of them have gone on to litigation. And either party can pull out of this. It's voluntary. It's not mandatory. And so if the person's lawyer and the person, if they don't agree and they want to pull out and go on to litigation, that's something that they can do, or vice versa in this situation.
Representative Silcox.
And I was just going to add to Chairman Cooper's remarks that most physicians live in great fear of being sued. Most physicians in Georgia are sued. All of them are sued at least once in their careers, regardless of their reputation or what have you. And so this will, I think, help reduce physician burnout, as you said, and anxiety on our very overworked healthcare providers.
Well, and the timetable on it, that it doesn't take 3 to 5 years like many of the court cases do, that it's got a 2-year time, limitation on it. And so it doesn't hang over, anybody's head for, 3 to 5 years. I think that's one of the really positives about it.
Okay.
There's closure.
All right. Any other questions? Seeing none, thank you. Any discussion by the committee? Motion and a second. All those in favor say aye. Aye. Any opposed?
No.
Bill passes.
Thank you very much.
We'll see you in 27 years.
No, I don't think you'll see me in 27 years. Thank you very much to the committee members.
All right, we're going to call up House Bill 382. You want to come up? No? You're right? Okay. All right.
All right. Is this on? It's on.
Go ahead and tell us about your bill.
Thank you, Mr. Chairman. I am Representative Terry Nulowitz. I'm here today to present House Bill 382. Thank you for taking the time to hear me out today, and I will try to be succinct. That is my goal. I'm working off of LC 480828. And let me pull up my notes. It just closed on me. But yes, this is a bill. It really is. It's fairly simple. It's certainly something that is happening in other states and other places, and I'm hoping that it's something that we'll be able to offer to victims and survivors here in Georgia. This is a victim-centered program. It's victim-centered, actually, restorative justice. And what the bill does is it helps provide a victim-centered option as an addition to or an alternative to the traditional legal system. These programs center survivors of crime. They look to them, the survivors, to dictate what accountability should look like for those who caused harm. It's an open and honest dialogue. It is a process. It is led by trained facilitators. That's a really important part of this. And one of the main things, it includes these defendants taking responsibility for their actions. That's a critical part of this. So what this bill would do is it adds evidentiary privilege to the evidence code for communications within a victim-centered program. That's necessary for these programs to exist. And we know that these programs work. We know that these programs are important to victims and to survivors. And we know it helps facilitate this process. So the privilege that would be in 382 mirrors other privileges that are already found in similar contexts like mediation, communications to a member of the clergy, apologies made by medical provider, communications between a victim of family violence or sexual assault, and agents providing services. So again, it's victim-centered. We want to provide an alternative to the traditional criminal legal system, but also have a path for accountability and restoration. This is a process that victims of a crime affirmatively opt into. No one is obligated to participate in one of these programs. The process is designed, and it's actually very important, the process is victim-centered. It puts the victim's needs first when discussing what accountability looks like. And I think that's the key thing to remember, because we know, and I've got a lot of letters of support that I'll talk about in just a moment, that demonstrate how important having this option is for these victims and for these survivors and for their communities. Because one of the things we all know is that it's very rare that a crime impacts only the victim. This is something that impacts their family members, their friends, their community members, so that they're a part of this process also, if, again, they choose to participate. Victims actually report satisfaction with this process at a much higher rate than within the traditional legal system. And these programs have also been demonstrated to reduce recidivism, which I know is something we would all like to see more of in Georgia. Central to these programs working the way they are intended to work is the acknowledgement of wrongdoing and the open dialogue. For that reason, there must be evidentiary privilege in place to allow the programs to flourish. Again, this would mirror the other privileges that I mentioned before, and without that, defendants will not take accountability, dialogue will be extremely limited, and victims will not obtain the healing that they seek. So the text of this new privilege as drafted is consistent with these other privileges. I'm happy to address any questions. If you don't mind, I'll go through just really quickly what this does. Line 18s to 20, these list the privileges that are currently listed by statute, and it then adds in line 23 the new section, which is OCGA. It would be 24-5-511. That's what creates the new code section. We get into the definitions defining the terms that are used in this process, and then going down into lines 43 to 47. This is where it's key, talking about that victim offender dialogue, and this refers to that facilitated dialogue between a person who caused the harm and a victim or their family. And again, this focuses on repairing harm, addressing the trauma, and reducing the likelihood of future harm. Lines 48 to 53, subsection B, that specifies that it specifies basically what is privileges, and that's the communications during, in preparation, or as a follow-up to a victim-centered program, as well as the fact that the program has been planned or convened. This means that the communication cannot be used in any proceeding unless the party protected by the privilege waives those privilege or an exception that applies, and again mirrors the plain statement of privilege found in multiple other statutory privileges. That includes, for the example I gave of communications to your clergy, a party or witness. That's all listed in here. Lines 56 through 58, that clarifies that parties of a victim offender program can both refuse to disclose a covered communication and prevent others from making such disclosures. 5961 clarifies that a waiver of the privilege applies to the waiving party only. Again, I can answer any further questions about this. We have language in lines 73 to 75, does not relieve anyone subject to mandatory reporting requirements from those duties. That's something that I felt was very important also. And then lines 76 to 81 will protect facilitators from any unnecessary lawsuits. And again, they would have had to have acted with gross negligence and malice or willful disregard of the safety or property of a party in order to be civilly liable for their actions in a victim-centered program. So again, I'm happy to take any questions that y'all might have, and you'll see in your folder, there are letters of support from Street Grace, from more than 41 faith leaders throughout Georgia, the YWCA, the Georgia Coalition Against Domestic Violence, the Georgia Commission on Family Violence, the Alliance for Safety and Justice, and Crime Survivors for Safety and Justice. And I've also been informed that the Prosecuting Attorney's Council has no objection to this legislation as well. And I'll take any questions that y'all might have.
All right, Representative Silcox.
Thank you, Mr. Chairman. This is really a neat idea, I think. My question would be, would this exempt the victim from testifying in a trial where they still needed their testimony?
That's a great question, and I'm going to turn to one of the attorneys that is here with me on this. Because I don't want to give the wrong answer, not being a lawyer.
Your mic is live.
All right. Good afternoon, everyone. My name is Wade Askew. I'm an attorney and the policy manager at Georgia Justice Project. And no, it would not exempt. If something did move forward to trial after one of these programs, it would not exempt. It would just mean that the communication specifically that happened within the context of one of these programs, that those would be privileged.
So the people that they worked with would be protected. They would not have to come and testify.
Well, it would, those decisions on who a prosecutor or a defense attorney, for that matter, would call to testify would be kind of independent of this. But they could not be asked, what did so-and-so say?
Right.
When, I know you guys had this program. What did he or she say? That is really the protection. If there are statements outside, or someone was a witness to something outside and they just so happened to be part of this program, then they could still be called as a witness to speak to what they saw, heard, etc., outside of the program. It's
Okay.
just protecting.
I think that would be important. Okay, great. So this is kind of a therapy for victims, a safe space for them to talk about their experience.
Well, to talk about their experience and also to explain why it's impacted them the way that it has, and I think it offers a way for the person who caused the harm to understand the impact, because I think it's different when you're having this conversation, and I know that Wade can speak to that in a much more knowledgeable way than I can, but it's when you're having this dialogue, and again, it's critical that this dialogue happen with a trained facilitator, and that's a key part of this. But it is something that can really help that survivor and also really help the perpetrator understand exactly the impact of what they did.
Okay, thank you.
Any other questions of the speakers? All right, seeing none. What's the pleasure of the committee? Oh,
My name is Rita Rocker. I'm with the State Board of Pardons and Paroles, and we house the Georgia Office of Victim Services.
you're gonna need to get in front of a
Okay.
microphone. Hang on just a second. She down, sweet.
Hi, I'll start all over. My name is Rita Rocker. I'm with the State Board of Pardons and Paroles. We house the Georgia Office of Victim Services, which represents the Department of Corrections, the Parole Board, and the Department of Community Supervision. We currently offer this program, Victim Offender Dialogue, after conviction. So, and my apologies to Representative Anulowicz, we were just able to speak like 30 minutes ago, I think, for the first time. But we have some proposed language that would cover us also, who would cover our victims that we're working with, that would make anything that is spoken about, discussed, and whatnot during victim offender dialogue would make that confidential also. So.
Okay, so your addition would be just to make it privileged so that
Right, it would cover post-conviction.
okay. Representative Silcox.
So are y'all opposed to the bill, or you're?
No, ma'am.
Okay, okay.
No, ma'am. We're just trying to cover victims post-conviction.
Okay.
Because this is really more prior to
Pre-conviction, right? Sounds
Yeah, so
like,
if
for
someone
sure.
didn't choose to opt into this program for whatever reason, and afterwards they are participating in the state program.
What is the specific language that you have?
Right. Yeah, oh, no, it's, well, it looks like, I mean, yeah, I can read it. So at line 55, it would, the language would add, and also not subject to disclosure under the Georgia Open Records Act. I guess we would need to get the code section in there. Yeah, so privileged information shall not be subject to discovery or disclosure in any judicial or extrajudicial proceeding and shall not be subject to disclosure under the Georgia Open Records Act. And I'm perfectly comfortable with that, absolutely.
Representative Reeves.
Looks like code section 50-18-70 and following would be the Georgia Open Records Act.
Thank you.
50-18-70.
Is that the only change?
Yes, sir.
All right. Anything else you want to tell us?
No, sir. That's it.
All right.
Unless
Any
anybody has
questions?
questions.
All right. Thank you.
Thank you.
All right.
Move to pass, Mr. Chairman, so we get to the amendment.
Amendment. Okay, yes. All right, have a motion and a second. Any discussion about the bill?
I'll offer that amendment.
All right. Do I hear a second on that? All right, so take up the amendment first, and let me make sure I've got this right. The wording is, what I wrote down was, and shall not be subject to the Georgia Open Records Act, OCGA 50-1870.
ETSEC.
ETSEC, okay. Anything else? Is that proper wording?
Let's go with you, Mr. Chairman.
Anybody have any question about the amendment? All right, all those in favor of the amendment say aye. Any opposed? All right, the amendment's in. I have a motion and a second on the bill. Any further discussion of the bill? Hearing none, all those in favor of the passage of the bill say aye. Any opposed? Bill passes.
Thank you.
You're welcome.
Thanks, everyone.
House Bill 368. Oh, and Chairman Irwin, this will be a hearing only at this time.
Got you. Okay. Thank you, Mr. Chairman and members. This bill, HB 368, which is LC 442274. Is that what you're working from?
Yes, sir.
This is a bill to move Banks County from the Piedmont Circuit to the Mountain Circuit is what is in the bill. We have done a feasibility study over the course of this past summer and fall. I will tell you that this is a recommendation, came from a resolution from the commission in Banks County, not only given to me, but given to the members in the Mountain Circuit, which would be Stevens County, Habersham County, and Rabun County, correct. Thank you. And just to give you a little bit of a rundown, Banks County is not a fast-growing community. Banks County is a slow-growing community of a little less than 20,000 citizens. The projection over the next 10 years is quite small. They've been well received by the individuals in the Mountain District that this would be a good move as they border them with a long border, as well as share some services. So in other words, the stakeholders in this involved and my constituents have come to me and have spoke to me that they feel that this is a proper placement for them versus the Piedmont Circuit. So with that, Mr. Chairman, I'll take any questions.
All right. Any questions by the committee? Whip or Chet?
Mr. Chairman, thank you. Thank you, Chairman Irwin, for bringing the bill. Did they give you any indication as to why? This is just my being here not too long. I have never seen one county move over to another district, so I just wanted to kind of get the background as to what's the reason.
Again, I think it's just purely the services, the fit for this. The travelability, the feasibility showed there were no judges living in Banks County, so judges would not have to be moved. Matter of fact, the judges in the Mountain District live closer to Banks than the judges, I'm told, in the Piedmont District. So it was what I would say a better fit is what the community felt like and why the commissioners gave me the recommendation.
Thank you, Mr. Chairman.
What's the setup in the circuit with any offices of the DA's office or of the judges there, where there's somebody regular that can be called upon if anybody has a question about what's going on in the courts?
I believe that of the last so many months that there has been a setup from the Piedmont Circuit where there is somebody. Now, in recent history, I don't believe there was that. I believe.
What office are they attached to? Are they attached to the DA's office or to the judge's?
DA's office, from
DA's
what I
office.
understand, Mr. Chairman.
So they have a full-time person there to answer the phone?
I'm not certain about that, Mr. Chairman, if there is one full-time there or not. There is somebody there, and there are times there now recently where the DA has been spending time and being a part of that. I am told that 10% of the cases that come before the Piedmont are from the Banks County District.
All right, and I don't know if the judges are planning on speaking. You are? Okay. All right, I think that I'll just save my question for them, so thank you.
Okay.
Chairman Smith?
Thank you, Mr. Chairman. Chairman Irwin, good to see you once again today. Thank you for coming to see my superintendent earlier. Real quick question that I have for you. How many counties are in the current circuit?
I believe there are 3, Banks County, Barrow County, and Jackson County.
And how many counties would be in this circuit you're proposing to move over to the new one?
There would be 4. There are currently 3 in that one also. Population dramatically different, though, in 2 of those counties in the current circuit.
Okay, thank you.
And when I mentioned population difference, I would talk about the size of the county. How many citizens are within Jackson County and Banks County, Jackson and Barrow County compared to Banks County?
Okay, so that I'm clear, the County Commission of Banks County wants this move. Is that right?
That's correct.
I guess the county commissioners in the Mountain Judicial Circuit in the 3 counties, they're also welcoming of this move?
The information from everyone I spoke to, which has been almost all of them in the 3 districts in which that are current there, are in acceptance to this, yes.
Okay, because that affects all of them if another
It
county
does.
comes in. Okay, so you got the counties, you got I take it the judges in the Mountain Judicial Circuit all in favor, or have they announced that? I believe I saw something from the chief judge that he's remaining neutral.
We have added recently a judge to this district, as I think y'all might remember last year, and I have not spoken to that judge. I have spoken to the other 2 judges, and they are in favor.
And the district attorney also in the Mountain Judicial Circuit is in favor of this?
Yes. Is in favor of this. Of course, he's recommending some extra help as an assistant to come in if he if this ends up occurring.
Yeah, he's made requests for appropriations already.
Correct.
So, yeah. All right. Any other questions by the committee? You number 2 down there? All right, go ahead.
Is the counties that are losing this affected in any way?
We did a feasibility study, and what I could determine there, the judges are not affected in the sense of living in Banks County. In that, obviously, that there would be a less of a caseload, but it would not mean that they would need to drop below the level of losing a judge.
Or running against anyone since they don't live there. Okay.
Correct.
All right. And Judge Scoggins?
Yes.
Have you got a microphone?
I don't. Okay. Hadn't it been a policy of ours that we require a resolution from all the government entities that's going to be affected by this before we'll do any kind of bill like this?
Yes, so that was a new rule that we put in.
That's what I thought.
Yeah.
Okay.
Vice Chair Reeves?
Did the Judicial Council study this at all? The 3 new judgeships a year, they do a statistical analysis and all that. Have they done that?
Vice Chair, I can't tell you the name of the group that did the feasibility study exactly. We requested it through an email, but the name of the group would be better deferred to somebody with that knowledge. So again, I'm not certain that that group has studied this in the sense. We did a feasibility study, and we had a couple of meetings about it, and of course it first had to be vetted out. Was it worth looking at? Would the financial end of it be feasible for the state of Georgia? And then ultimately, did it affect the judges?
I think we found out on the Albany judgeship, they're the ones who go collect the letters from the local judges and counties in their process.
Okay.
Chairman Smith.
Thank you, Mr. Chairman. Chairman Irvin, you mentioned something about appropriation by a request from the district attorney's office. What about the public defender's office? Do we know if there's money for that in the budget?
What we did was we wrote in this bill for a memorandum of agreement or a memorandum of understanding so that they could then work that out if this move is made between Banks County and that circuit.
Okay, so is there a scenario where you see that the DA could get their appropriation but the public defender could not?
No.
Okay, thank
you. Representative Kelly.
Thank you, Mr. Chairman. Chairman Irwin, just had a question or two for you, trying to better understand the circuits. What's the population of Banks County?
Just under 20,000.
And what's the population of Barrow County?
That's a good question. Again, I believe it was, yes, about 80,000.
Do you know about Jackson County?
I believe it's 65,000 or greater.
Okay. And do you happen to know approximately, and our chairman here may be able to speak more to the populations of Habersham, Rabun, and Stevens?
They would each about 30,000 each on average.
Habersham's a little bit larger, I believe, than 30,000.
Yeah.
Rabun is
18,000.
Yeah, I was going to say a little less than 20,000, and Stevens County's going to be somewhere in the 28,000, little under 30, I believe.
I'm just
the growth difference is very important to pay attention to, though. I think that Jackson County and Barrow County are two of our fastest growing counties in the state of Georgia.
Thank you for that. And when's the last time a district attorney was elected that lived in Banks County?
Ooh, that's a very good question. Long time. I don't recall one in my times of being there.
What about a judge?
I don't recall one.
Okay. All right. Thank you.
Yeah. All right. Any other questions? All right. At this time, I'll call on the judges. Do y'all want to come together or separate? You want to just pull that first microphone up to you?
All right, thank you, Mr. Chairman and members of the committee. I'm grateful for the opportunity, and I'm also aware that time is very important, and so if I talk too fast, to slow me down. If you have questions, I'll leave them. Judge Mingledorff, my colleague, is here, and we'll say a word or two as well. Our other colleagues, Judge Nick Prim and Judge Wayne McLaughlin, are both on the bench today, could not come on short notice, but they join us in opposing this bill. We think this is a bad idea, and we are unanimously opposed to it, as are our Chief Public Defender, Donna Seagraves, who could not come on short notice, our Chief Juvenile Court Judge, Bill Hicks, who couldn't come on short notice, and I can't leave without saying my court reporter, whose firm supplies the court reporters for all of the circuit, who would take a financial loss if this took place. We do not think this is a good idea. I had heard a number trotted out that Banks County would save some $100,000. i.e. that they pay some 200 and something to the Piedmont to be a member of the Piedmont Circuit, and that a county of similar size, Rabun, pays only some 100,000, ergo a savings. There's no analysis there about how many positions of assistant DAs or assistant public defenders or intergovernmental agreements that govern law clerks and secretaries and supplements for judges. I don't know what those judges' supplements are, but there's no serious analysis about that. We've already heard from Representative Irwin that the DA is going to need another slot. Our Bill Hicks has talked to the juvenile judge up there. They have one juvenile judge, would have 4 counties, would have to have another juvenile judge. This is going to cost money. This is not going to save Banks County any money. There is much more that I could say about that. I'm going to ask, and I do have another word or two to say about it, but I'm going to ask Judge Mingledorf. I'm sorry, I did not introduce our very fine District Attorney Brad Smith is here. Mr. Andy Crawford, an assistant DA. Our court administrator, Steve Nevels, is here. And I know that Judge Mingledorf wants to speak and say a word, and then I have another word to say, and we'll be able to answer questions.
Judge Booth, can I ask y'all a question? What are the terms of the court in Banks County? Are they 6-month terms?
Yes,
is that what they are?
All 3 counties now, by statute, have a new term of court that begins the first Monday in February and the first Monday in August.
And in Banks County, is there a satellite district attorney's office?
The district attorney's office is in Banks County. On my recent trips, not only is Brad Smith personally there, but a new assistant DA who has been hired in the last 6 months is there on site every day.
Okay, all right, thank you.
I'll just make an observation too. There's been some criticism and sort of a whisper campaign to the commissioners about us not being up there, and that is that. Oh, the Piedmont Circuit now has 4 judges in 3 counties. Why don't we have one parked up here all the time? And the answer is just what Representative Irwin alluded to. It's 10%. 90% of our work is in Barrow and in Jackson. It is not practical. It is not effective. It's not responsible for us to park a secretary up there or a judge and be like the Maytag repairman waiting on somebody to walk in the door. One of us is up there at least 3 days of the week, many times more. On every occasion, we take an assistant and a law clerk, and we are there to more than adequately meet the needs of Banks County. But it's not productive and it's not responsible for us just to park somebody up there just for image, and that is a part of what's in the crawl of these commissioners. And I'll also just observe, it's my understanding that there's not unanimity on the commission board, at least there wasn't fairly recently. Representative Irwin, I may be wrong about that now, but I understood that there was less than unanimity about this move among the commission board. But I'd defer to your last conversation there if I'm wrong about that.
So, one other question about the grand juries in Banks County. I know you're there for that, so you got one every 6 months?
Yes, and they call, the DA's office calls them back in the middle of that term, so they come every 3 months.
Okay.
We just, I just opened 16 indictments from the last, which doesn't sound like much to the metro counties or many of the other counties, but the grand jury just met last week.
Okay, all right, thank you. Judge Mingledorf, do you want to speak? You can come up here if you want.
And good afternoon.
You might want to pull that microphone up.
Good afternoon to all of you. And at the risk of sounding like I'm sucking up, like sometimes people do to judges when they come into the courtroom, I do want to say thank you for what you do. I have known Chairman Gunter for a long time, and I think it's really great that you have a former Superior Court judge who chairs this committee. I want to clarify one thing that Judge Booth said about parking somebody up there. I want to make sure that we don't leave any of you with the impression that we're not up there except for very limited times. Every one of the 4 judges have a regular rotating docket, and somebody's up there virtually every day or several times a week. And so we, it's not like we don't schedule a calendar up there. We frequently go. Our calendar is relatively brief. There are times when I'll have a morning calendar, and then I'll rush out to go and preside over drug court in Jackson County or something like that. But I guess what I really want to say to this body is that I'm grateful to the citizens of Banks County for having elected me now 4 times to serve as a Superior Court judge there. I'm really here because, like Judge Booth, there's this kind of undercurrent that I'm concerned that there's a record that we disagree with any sense that Banks County is underserved because they're part of the Piedmont Judicial Circuit. Now, I have one big regret. I had the opportunity to preside over the creation of the first drug court and then mental health court in Barrow County about 10 years ago, maybe 12 years ago, not long after I took the bench. A year or so later, took that same structure and placed it in Jackson County, so that we have mental health courts and drug courts in both counties, and felt very, very strongly that Banks County needed to have the same benefit of those kinds of courts in Banks County. I worked diligently and arranged to have a highly regarded treatment provider, Project Adam, who serves our Barrow County program. They were going to put a satellite office in Commerce, which would serve Banks County. We were in DFACS and FACS was going to open up. I don't know if they ever did open up because they were going to do this together, but was going to open up a satellite office up in Commerce so they could provide parenting classes, not only to some of our participants, but to others. And we just, and I talked with the sheriff who had come from, Sheriff Speed, who's here, who had come from Hall County and had told me that in his experience there, they have lots of accountability courts. He was very much in favor of it. And we were going to use the DATE funds, which are the Drug Awareness Treatment Education Fund. You know, it's a fine that's on a lot of sentences to fund what we were going to do there. And I'm not sure exactly what happened, but I was so excited when we got it all ready to go. And I felt I ought to share that with Tim Harper, who is also here, who's the Honorable Clerk of the Court. Tim is as well a connected individual in Banks County as anybody. And so I told him in my excitement, hey, we're going to do this. I just wanted you to know about it. And 5 minutes later, I get a call from the sheriff that, he wasn't, he was no longer in agreement with the whole thing, that we weren't going to have, he wasn't going to be able to share the DATE fund so that this could happen. And so it didn't happen. I've been doing accountability courts long enough, and our courts in both of our counties, Barrow and Jackson, are model courts. They're recognized by the state. But I took that as something of a shunning that even though I was prepared to along with the whole rest of my docket, take on this added burden, we were pressed away. And there's one other thing I really want to say. And that is, in the time since then, one of the more somber responsibilities that I have as a Superior Court judge is when probation comes to me and says, hey, so-and-so's been on our probation docket, and we want to be relieved of responsibility, and their death certificate is attached, and they died of an overdose. And I have just mourned and grieved over that. But I love, it's a beautiful county. There are beautiful people there. There are people that I have loved to serve and would love to continue to have the opportunity I do know that the burden for the supplements that we pay, we receive a modest judicial supplement from Banks County. I do believe that would have to be somehow pressed on to the other counties. I do think that counties should be able to decide things for themselves, but I wanted to be heard and let you know that we're willing to continue to serve Banks County.
All right.
And thank you.
All right, any questions by the committee? Representative Reeves.
Judge, this question is for you or Judge Booth. And before I ask the question, let me just say, whichever county this circuit ends up in, or vice versa, you got a great House of Representatives member who represents Banks County well. I think I've been to all the counties in both circuits, but let me just make sure we got the map right. It's Toccoa, it's Clayton, and it's Clarksville. That's in one circuit. That's the one that Banks County wants to go to. And then you've got Winder and Jefferson and Homer in the other right now. And the judges are you two, Judge Prim and Judge McLaughlin in the Winder circuit that Banks County is currently in. And then you got Judge Caudell and Smith, and who else in the Mountain Circuit?
Bill Oliver. Bill Oliver's the new judge.
New judge, so 3 in the other. And the DAs in the DA in the Piedmont Circuit, the current circuit is who?
Brad
Smith. Okay, here. All right, we got Mr. Smith here. In the Mountain Circuit, who is it?
George Christian.
Okay. Former federal prosecutor, right? From Macon. Okay, yeah. Let me tell you, after sitting through 2 days of DA oversight hearings, there are wide varieties of counties and circuits in Georgia. Those are 2 good choices wherever this county stays or goes. You've got top-notch judges, counties, DAs, and all those. So whatever y'all are doing is working in all those counties. Keep it up.
All right. Chairman Smith.
May I answer one question you posed about the study? JWAC, or the Judicial Workload Assessment Committee of Judicial Council, was requested by Representative Irwin on a timely basis to do the study. They turned out a feasibility study, and our chairperson, Judge Leonard from Cobb County, chaired that committee and made clear repeatedly that by saying that this move was technically feasible was not an endorsement. Judicial Council doesn't sign on thumbs up or thumbs down. They actually, I was surprised to learn that whenever a boundary survey like this is requested, they look at every other possible scenario that would affect the surrounding circuits, came up with a list of 9, 2 other of which were deemed to be feasible, neither of which were requested, one of which included us joining the Western Circuit. And the judges there, Judge Norris weighed in and said, we love you guys, but you keep your cases, we'll keep ours. And Judge Ott, I think, was still the chief judge in the Alcovey Circuit and said pretty much the same thing. We didn't ask for this study. We don't need to merge. We don't need you all. Good luck to you. But it was not a recommendation. It was simply that this could be done because of the residences, respectively, of the judges. I live in Jackson County. I'm 18 miles from the Barrow County Courthouse. I'd be surprised that, if there's one up there that's closer, but I think I'm probably the closest to Banks County.
Okay. Chairman Smith.
Thank you, Mr. Chairman. Judges, thank y'all for being here with us today. I know y'all got busy dockets and y'all handling everything for somebody kicking a dog up to murder, so we appreciate y'all coming today. Let me ask you this. How do all the agencies get along with each other? Judges and district attorney, public defender's office, sheriff's office, Department of Community Service, community supervision or clerks? I mean, how's everybody get along?
I would say that the Piedmont Judicial Circuit is probably the most collegial circuit in the state of Georgia. I can't imagine a circuit that is less collegial, although after the deal, I will say that, and for me it was in a day's work. I suppressed the evidence in a case, and it was picked up in the news media because it involved a Atlanta Hawks player, and And for me, it was in a day's work. It was what I have to do as a judge. And but because it was picked up, and because the sheriff, well, I can't speak for the sheriff, but I'll just say that he hasn't really spoken to me since then. But aside from that, our relationships, and I have nothing against the sheriff, honestly, nothing at all. But aside from that is the only exception to our circuit being the most collegial, pleasant place to practice and to work that I've ever been in. And I practiced for 22 years before I took the bench.
Yes, sir. So everybody was geeing and hawing up there pretty well until that decision.
That is my take on that.
Okay. Thank you. Appreciate you.
Yes,
Honor.
sir.
Representative Smith, if I can add to that, Judge Mingledorff very correctly is measured with his comments. He was the trial judge on that. But at the core of this dispute is an issue which is neither complex nor complicated. It is that the sheriff is ill with the district attorney. And he came to me, he'll recall it if he's honest about it, some 6 years ago and said, we have nothing in common with Bear County. We have a lot in common with Jackson County. Why don't we talk about splitting Bear County off and be its own circuit, and Jackson and Banks will stay together? Well, that idea died a slow death, as it should have, because there was no reason to do it other than just the fact that in a moment of honesty, he told me that we can never elect a DA. Brad Smith lives in Bear County, and that was the problem. And I've heard that repeated from the former commission chairman. We can't elect our own DA, and we don't like the DA. So this is an attempt to carve out Brad Smith. When that didn't go anywhere, and this Michael Scott case bubbled up, I'm going to tell you, it lit the sheriff's department up. To his credit, Sheriff Speed fired the deputy who was racially profiling drivers and pulling over non-white drivers in Banks County on an incredible basis. And that was an ugly scene. And Judge Mingledorff handled the case, but it didn't sit well with the sheriff, and it hadn't sat well with him since. And that is what is at the core of this. Now, I'm sorry to say it, but that's the problem. And to answer your question, I think we get along great. I have gotten along fine with the sheriff. And that's what's at the bottom of this. I've noticed, Mr. Chairman, that y'all have voted immediately after these proceedings. I have an AJC article that breaks that down for all of you, if you would be interested. If you're going to vote right after this, you're not going to have time to read it, but.
No, we're going to hold this, this is hearing only.
Okay, all right. I will leave that with you and encourage you to read that, and if you find that to be instructive, then so be it.
Representative Irwin.
Let me add to that if I can. Mr. Chairman and members, I dropped this bill I dropped the bill. This was not with any relationship that I've had with either the sheriff or the DA or any knowledge of any not getting along. I'm obviously not in the middle of that. This is my constituency coming to me from two of my counties, one of them being Stevens County and the other one being Banks County. Started in Banks, and I decided to investigate the feasibility of this and how to make this work, which was going to be best for my constituents that are also outside the courtroom, that aren't all in the courtroom, that are what I'll say out in the neighborhoods talking. And so this is what I felt best to do for the constituents in which I serve.
Okay. Thank you for that. Any other questions? All right. Seeing none, I don't have any other speakers signed up, so thank you, gentlemen.
May I make one final observation about this?
Yes, sir.
It occurs to me, and I speak not for my colleagues on the bench, but just for me. It occurs to me that if this goes through, what the legislature and the governor will be telling the good citizens of Banks County that we know that you voted for and elected 4 Superior Court judges and a district attorney. Overwhelmingly. We had no opposition. But these officials took an oath, were issued a commission, have been serving, I think, responsibly. And to do this goes back to those voters and said, we're canceling your election. We're removing the people that you elected. Here are your new Superior Court judges and your new DA who you did not vote for, who you did not elect, who you may not even know, and I hope you like it. And it's just not right. And I don't think it is legally sustainable.
All right. Thank y'all. Appreciate y'all being here. Thank you for the information.
Mr. Chairman, I'm going to hand this packet to Representative Evans, and there should be a copy of this article for each. Thank you. Thank you, Chris. Always good. My pleasure. Thanks so much for your work. Appreciate you. Okay. Thank you so much.
All right, at this time, I'll call House Bill 563. Chairman Leverett.
Ms. Cross, you want to come on over?
All right, Chairman Leverett, if you would, go ahead.
Thank you, Mr. Chairman. I appreciate your agreeing to place this on the agenda for today. This is House Bill 563. This is the bill as filed, LC 442294, and this seeks to make some changes in the state statutes that govern implementation of the policies of the Civil Rights Act, Title VII of the Civil Rights Act, the Equal Employment Opportunity Act, Age Discrimination Employment, and so forth. There is a Fair Employment Practices Act of 1978, which the Commission on Equal Opportunity here in Georgia basically tries to implement and further and provide a process for folks who feel they have been the subject of discrimination. They can file complaints, and then there's a process that the Commission oversees through which those complaints can be heard administratively. And this bill would change some of those procedures. Actually, our freshman Representative Martinez was, I think, on the commission at one point, was not. So he's a co-sponsor, and I appreciate him co-sponsoring, and some of the other members of the committee. But the process has traditionally been a special master process. They maintain a list of private attorneys who can serve as the special master when a complaint is filed, that the special master kind of hears the matter and issues a report. And that's been a very good process, but it also has been a rather expensive one, I think. And so we're trying to shift from that sort of paradigm to just utilizing the Office of State Administrative Hearings, administrative law judges, and hearing officers, and making it a more uniform process with a sort of known procedure applied by OSAH. So the Act basically does that. We're striking references to special master, except in the case where the Office of State Administrative Hearings itself is the respondent, and then there would be a special master appointed. We also, in the Act, I believe, addressed amendment of the complaints. Right now, there's a fairly rigid rule on amending complaints. We're trying to make that a little broader, consistent with the Fair Housing Discrimination Act processes. We borrow some language there. And we also are addressing, I think, some discovery matters and being able to compel production of discovery. So I know, given the time of year it is, I did not think the chairman would want me to make the line-by-line review for which this committee has transcended the everyday and entered the realm of legend. I thought you might prefer just a more summary sort of a discussion. And Director Alana Cross is here also just to briefly offer some testimony.
Amen. All right. Before we go on, I have got to recognize the judicial celebrity we have here today. Is Burt Guy. Good to have you here, Judge. Thank you. And you are our judge for the week, is that right? All right, awesome.
Bottom of the barrel this week.
It's good to see you. All right, Ms. Cross.
Good afternoon, Mr. Chairman and members of the committee. My name is Alana Cross, and I serve as the Executive Director of the Georgia Commission on Equal Opportunity, Office of the Governor. It is a pleasure to be here with you all today, and my remarks will be very brief. The bill to amend the Georgia Fair Employment Practices Act is essentially cleanup legislation, as Representative Leverett stated. The act, to our knowledge, has not been amended since 1978, and as you can imagine, the need to change and improve processes and procedures is essential and vital to ensure that the Equal Employment Division is able to continue to function and operate efficiently and effectively. And by amending the act, we will be able to allow for administrative and procedural changes that will equate to a more efficient complaint process, not only for GCO employees, but also for Georgia citizens, for state employees, for state agencies, and state colleges and universities. So thank you for your consideration, and I look forward to answering any questions you all may have at this time.
All right. Are there any questions by the committee? Seeing none, what's the will of the committee? I got a motion to pass. I have a second. Any further discussion? All those in favor say aye. Aye. Any opposed? Thank you. Bill passes.
Thank you,
Thank
Mr.
you.
Chairman.
Thank you,
members
Mr.
of the
Chairman.
committee. And thank you, Ms. Grohl.
Thank you, Mr. Leverett.
I'll go back to my assigned seat.
Vice Chair Reeves, you want to do your 292? As he's coming up, I'll state that I had a bill last year that dealt with non-judicial foreclosure of timeshare estates, and this is a bill that amends that and adds to foreclosures in timeshares. So if you would, go ahead and explain it.
Thank you, Mr. Chairman. This is House Bill 292. We had an economic development bill regarding arbitrations earlier in the session, and this one may also be our second economic development bill. Last year, Chairman Gunner, as he mentioned, worked hard on improving timeshare legal procedures, and there are 18 timeshares currently in Georgia, and 5 of them are up in the mountains, well represented by the chairman. However, Florida is the #1 timeshare state in the country. South Carolina is #3. Florida has 367 timeshare facilities. South Carolina has over 100, and we have 18. So what this bill is designed to do is brought by some industry folks who are familiar with lending and title insurance on timeshares and success stories of timeshares in other states. They had some ideas on how to take the next step and make timeshare law in Georgia more in sync with some of the states where timeshares are flourishing. And so after a lot of discussion, and I thank Vernon Lee, Vernon's here. Vernon represented the current 18 timeshares, a number of them up in North Georgia and Chairman Gunner's area well. And what we did is we made sure that this bill is separated from last year's law. This bill would be separate and would give an alternative procedure for timeshare title issues and foreclosures for the benefit of lenders, title insurance, and other national timeshare companies to make Georgia more attractive on the legal and real estate and lending landscape, and make us more standard for those larger timeshare companies so that they would be more attracted to Georgia. But it left alone the 18 present ones and the good bill that Chairman Gunner and many of you on this committee helped pass last year. It provides an additional set of laws for more national-oriented timeshare owners, lenders, title insurance to be able to understand Georgia's legal landscape. So I have a lot of statistics. I have people here who are prepared to talk more about the bill if the committee would like to hear it, or I could just stop at this
Brevity
point
is appreciated,
and
yes.
be prepared to answer any questions. So I'll go as in-depth as the committee would want to hear, but I know the hour is late.
Okay. Question?
Okay, Representative Reeves, did this change anything from last year? Did it make it more difficult for the people to, I guess, foreclose on the timeshares? Did it make it any more difficult?
The LC sub in front of you, 365543S, separates it from what you did last year. So there's
So-
still a simple short form procedure that is well liked by the 18 current timeshare folks. It's very simple. This bill provides a separate process for the bigger and more, national-oriented timeshare owners, lenders, title insurance companies, and things like that. So
Well,
it separates it out.
I knew Judge Gunner always dotted the i's and crossed the t's, so I
And-
thought we had a good bill last year.
And Chairman Gunner has been very patient with a lot of the communication that's gone on in this bill, and has probably been more involved than he wanted to be when it got filed. But this is a different bill than the one that was dropped a few weeks or months ago. It separates out and completely leaves intact the more simplified approach that you did last year. It merely provides a separate set of statutes for different types of timeshare businesses in hopes that they will do more business here in Georgia.
Thank you for
Do
that
we have
explanation.
any of those now in Georgia, those type of timeshares?
And
Yes,
Ye-
Mr. Chair.
come on up, Steve Tippins.
Mr. Chair, thank you very much. To answer the question, yes, sir, you have quite a few. There's one actually here in Atlanta that Wyndham Resorts just opened up, Margaritaville, right around the corner. So the national organizations do find Georgia lucrative, and we believe this new landscape, as Representative Reeves put it, would be attractive to further development, such as what Wyndham just invested in here in downtown Atlanta.
Okay, but the smaller operations would be unaffected from this bill, is that right?
Yes, sir, that is correct.
Okay, thank you. Any other questions? Do I hear a motion?
Move to pass, Mr. Chairman.
A motion and second. Any further discussion? All those in favor say aye. Any opposed? Hearing none, it passes.
Thanks a lot.
All right, thank you.
May we be excused?
Yes,
Thank
you
you.
may. All right. Smith, we're ready for your bill now. You got the last bill. You know what that means. Brevity. All right, and by the way, folks, we did 10 bills today when we get this one done, and we have a few to do on Thursday, and there's some being added to the schedule, but I don't expect any more than what we have now to be on for Thursday, and I also expect those to move relatively quick as well. My goal is to get us out of here on Thursday afternoon and not have to come back in on Friday. So, all right, Chairman Smith.
I think that may be because Judy Non-Civil might be looking at meeting on Friday. Mr. Chairman, if you'll indulge me just a minute. I had a high school coach of mine that taught me American government. He was watching in earlier, and just want to give a shout out to Coach Armis. I appreciate him watching in. Mr. Chairman, thanks for holding me till last. You know, it's biblical apparently. The first shall be last, and the last shall be first. So, which I've got you another quote. You know, Matthew, I think it's 22nd chapter or so, talks about rendering to Caesar that which is Caesar's. I want to say that was Jesus' response to
To a
Pharisees.
lawyer's question.
Yeah, a lawyer question. So I'll start out with that. I bring to you this bill. It's a bill that Whip Burchett had worked very hard on last year and was glad to be a part of that effort. And so this is dealing with misclassification of workers. Basically, this is under-the-counter transactions going on, while those who have to obey the rules, they're penalized for that. They're held on a different playing level. So just to go through this real briefly, the misclassification of workers is a growing illegal trend. The numbers for the state of Georgia is that we are losing over $275 million in this misclassification that's going on with our workers. The figure might actually be more. That's just on some of the numbers we know. So this bill will bring everybody on the level playing field and make sure that we're paying the taxes that we should be for employers in this state, and that underhanded, dirty dealing is no longer going on. So, in essence,
Chairman Smith, let me ask you that: would this affect our agriculture industry?
it may very well could, Mr. Chairman. Couldn't say for sure or not, but it very well could.
Okay.
But a lot of the situations you hear about are one particular instance that I can think of are HVAC workers. Everybody's switching over. I don't know about y'all. I got propane heaters at the house. I got an old house that was built back in the 40s. And so everybody's getting those air conditioners back to roaring with the temperature being in the 70s. It's hot weather for us this time of year. So HVAC's one of those situations. I mean, you've got heating and air guys that can't compete because the other HVAC guy that services the area, he's misclassifying his workers. And it's really hurting them. I mean, you think about this as far as understanding of credit. That's something that I'm always a fan of, is helping those with certain populations that may very well not know that much about credit. It's not just hurting the state. It's not just hurting competition. It's hurting these people that are being paid under the table, being misclassified. I mean, as far as them trying to go get a loan to make a better life for themselves and maybe getting a better home, it's just really a disservice to them at the end of the day, these very workers that are misclassified. So, in essence, that's the bill, Mr. Chairman.
All right, thank you. Any questions by the committee? Representative Holcomb.
Thank you, Mr. Chairman. Mr. Chairman, would you agree that there are very clear rules already in existence in terms of when one is an employee and when one is an independent contractor, but what you're seeking to do is to make sure that people are actually put into the right buckets, and if not, there's a redress, correct?
I wholeheartedly agree, yes, sir.
Thank you.
Okay. Chair Whip Burchett.
Thank you, Mr. Chairman. Thank you, Chairman Smith, for bringing the bill. So I think it's a good bill. And just sort of to answer the chairman's question, there is no legislation in the state of Georgia that wouldn't impact agriculture.
Yeah. You know, more I think about that, Mr. Whip, I think you're exactly right. I mean, you know, and everything we do, lease agreements. I mean, I was thinking about that coastal marshland bill. I mean, that even affects it a whole lot too. So yes, sir. Thank you, Mr. Whip.
Thank you, Mr. Chairman.
Okay. Any other questions? Do I hear a motion?
Motion passed.
All right, got a motion and a second.
And I'd like to make a friendly amendment.
Hey, hang on. What number is that?
I don't have one.
All right.
I don't rank high enough to have one over here at my.
All right.
That's a true statement. Okay, Mr. Chair, I'd like to offer a friendly amendment. If we could put it in after line 22, that this provision shall not apply to anyone involved in the agricultural industries throughout the state.
No, when you say to anyone, are you talking about the business owner?
Mm-hmm. Agricultural business, industries. Industries is what I said.
Shall not apply to the agricultural business. Y'all got a better wording than that.
I just got a question.
Yes,
Because
sir.
I do think we may need a further definition. You know, we heard the chairman talk about the HVAC industry. What if somebody's installing fans on a chicken house? Is that the agriculture industry or the HVAC industry? That's what I'm kind of trying to figure out. I mean, if I'm a carpenter building a chicken coop, am I a carpenter or working in the agriculture industry?
Scored on how much they pay.
You're in the
Yeah, if you're underpaid, you're in agriculture.
Yeah, the HVAC.
Because I understand the gentleman's intent. I'm just wondering if there's a way we ought to define that, Paul, or if there's a ISO code or something we ought to reference.
If Mr. Higbee has any suggestions on that.
I could come up with some, not right this second.
Representative Evans.
Thank you, Mr. Chairman. And ultimately, whether a friendly amendment is accepted is up to the author and always up to the chairman. But I just think it's bad policy for us to say it's okay for any certain kind of employer to violate the law, but it's not okay for everybody else. And so I would certainly be against such an amendment.
Let me comment on that, Mr. Chairman.
Sure.
You know, a lot of these farmers get these workers in, and they only work one day at a time, and then they're gone. You know, they get a lot of day labor on these farms, especially during in the spring and when they're picking crops and that kind of stuff. So there's a lot of times they only maybe work this person 1 day or 2 days, and then they're gone, you know. And so that's the whole intent of my amendment, was just to those type of situations. Makes it tough on the farmer to do that.
And from my, I'm married into a family of farmers, chicken farmers, that kind of stuff. But not
I'm one myself.
Yeah,
so.
But everything I hear from them, because they're heavily involved in agriculture throughout the state, that the harvesting of crops in Georgia, if we didn't have that kind of help, it wouldn't happen.
Exactly.
All right, Representative Evans.
Thank you, Mr. Chairman. And I would defer to folks that practice more in employment law, but I would have a hard time believing that somebody that picks up a job for 1 day would ever be considered an employee. So I don't think that we would be at risk. We wouldn't be risking that industry being brought into this, if that's what we're talking about, day labor.
All right. Whip Burchett.
Thank you, Mr. Chairman, and to my discussion as to the amendment. When I brought the bill last year, I had a friend of ours who's now moved on to what he considers the upper chamber across the hall, and he had this concern as well with regard to H-2A workers. But I reminded my friend that these H-2A workers they're under strict guidelines, the farmers and the workers themselves. And so I don't think that this legislation would impact those workers if that is what the aim is for agriculture. And you know, I have to agree with, some folks that have said that, we needed this essentially as to level the playing field for every employer. I mean, I would say that our farmers are having to follow that H-2A program, and that also would make them be in compliance with this piece of legislation and wouldn't be misclassified because they're withdrawing taxes, and that's what this really ultimately boils down to. Representative Chairman Smith said the HVAC folks, but this is all your tradesmen. I've got the impetus for this. When I brought the bill was, I had a concrete man that came to me and said, "Hey, I've called the Department of Labor and let them know that I've got people leaving from working for me because I'm taking taxes out, and they're going to work for another contractor who is just paying them on a day rate as an employee." And he himself and myself tried to bring that to the attention of the appropriate folks to seek action on it, but because this other employer never took out taxes, was just working these folks as on $150 a day, they were not in the system, and they couldn't be sought after by the departments. And so I feel it's only fair and right, if we're going to set some parameters for how we're supposed to withdraw taxes and how we classify our employees, that everybody must play by the rules. Even if they're not in the system, they are competing with those folks that are playing by the rules. You know, they're trying to do right. And here's what adds insult to injury. The gentleman that reached out to me and we made the notification to the appropriate departments, he was just he was losing his employees, like literally losing it. They were saying, if you so and so does this, if you can't pay me $150 a day, then I'm leaving, and they're leaving. So we raised that to the attention of the appropriate departments. My guy that calls me gets audited twice, because and he actually gets fined for saying that. Because they said he was not doing it right with someone that was temporary labor, came once in a while to work, and he paid him as a contractor, used his own trucks, used his own tools. All he did was say, this is the job I want you to go do, and go do it. They fined him for this guy that was classified as a contractor, and I believe is a contractor, this guy also works for another employer, but that employer is not in the system. So they can't go out. They can't go out after them. So this gives an opportunity for those folks that are in the business to self-police. And I know there's apprehension on some of our parties, interested parties' side, but this is just common sense to try and help these folks out. There shouldn't be a repercussion for somebody that's trying to follow the law and classify correctly, and then. And them have the department come back on them because they're asking questions. Why are you not, enforcing these laws evenly throughout the throughout our community?
Well, let me clarify. Does this apply to agriculture day laborers?
This will apply to any business that has an employee or contractor. Hires employees or contractors.
Okay.
I believe
Representative Holcomb.
Yes, Mr. Chairman. I have some experience with this. It's not my main focus, but the basic standard for an independent contractor is if that person controls when they work, the hours of the work, the circumstances. So I don't see how a day laborer would fit that definition ever. So I think we'll be fine. It's really the circumstances where you work weeks and months at a time, and where the abuse is when people work years at a time and they're treated as an independent contractor. So I feel pretty comfortable that seasonal workers, day workers, et cetera, can continue to be classified as independent contractors and not get sideways with our very important agricultural industry, and that there's no disconnect between what Chairman Smith is trying to do and what you're trying to do.
Okay, yeah, I just don't want to cause Senator Eccles' husband any problems with his business, so if you know what I'm talking about. Chairman Leverett.
Thank you, Mr. Chairman. My recollection last year is we had some concern about who could sue. It was rather broad. Basically, anybody, I think, can sue as the bill is drafted. And so if I'm not mistaken, we tried to address that by providing that a bond would have to be posted, and you could get an award of attorney's fees if the lawsuit was not successful, the defendant. But otherwise, it is unlimited, I suppose. You don't have to show the whole point is you don't have to show any kind of standing. Anybody can sue a nonprofit from California could arguably sue to enforce this, couldn't they? If they post the bond.
Okay. All right, thank you. Oops. All right. I'm waiting to see. Any further discussion about the amendment?
Mr. Chairman, if anybody's asked my opinion on it, sounds like Whit Burchett's discussion kind of puts at bay any of those interests. So, I mean, if...
I'll withdraw my amendment.
Withdraw. All right, it's withdrawn. All right. Any further discussion about the bill? Do I hear a motion?
Move to pass.
Second. Got a motion and a second. All those in favor say aye. Aye. Any opposed? All right, bill passes.
Thank you, Mr. Chairman.
All right,
Members of
folks,
the committee.
Thursday, we'll have some bills on the calendar. It'll be Thursday afternoon after the session, and hopefully we'll get done as quick then as we did now.
Paul's, that's some of your.